cultural property content and copyright in Japan. Digitalizing copyrighted works and uploading them to the internet can infringe upon the right of reproduction, Article 21 of the Copyright Act, and the right of public transmission, Article 23, Paragraph 1, held by the copyright owner. Currently, the Japanese Copyright Act contains no specific limitations on copyright, legal exceptions, that allow local governments or cultural heritage research institutions to upload full reports for public viewing without the permission of the rights holder. Copyright is defined as an exclusive proprietary right to use a work and the authority to grant others permission to use it. Q1. What is the public domain? PD. A. It refers to works whose copyright has expired for reasons such as the end of the protection period. While public domain is not a formal Japanese legal term, it is the common name for this status. Works in the PD can be used by anyone, including for commercial purposes, without seeking permission from the original copyright owner. Q2. How long does it take for cultural property to enter the PD? A. If a cultural property is considered a copyrighted work, the expiration date depends on whether the work is attributed to a real name, a pseudonym, or an organization. Protection periods are complex due to recent legal changes, but here are the general rules. Works by a single author, real name. If the author passed away by the end of 1967, the copyright has expired. Works by a pseudonym, pen names. If the author's real name is not well known and the work was published by the end of 1967, the copyright has expired. Works under a corporate organizational name. Under current law, copyright expires 70 years after publication, Article 53, Paragraph 1. However, before the TPP 11 legal reforms took effect, prior to December 30, 2018, the protection period was 50 years. Based on the standards at that time, any work published under an organization's name by the end of 1967 had already seen its copyright expire. Crucially, once a copyright expires, it does not revive, even if the law changes later, per the supplementary provisions of Act No. 108 of 2016. Case 1. Byodo-in Temple and the Jigsaw Puzzle Lawsuit. In October 2020, it was reported that a settlement was reached between Byodo-in Temple and a toy company. The temple had sued the company for selling jigsaw puzzles featuring photos of the Phoenix Hall, a national treasure, without permission. Outcome. As part of the settlement, the toy company agreed to dispose of the remaining puzzles. Interestingly, Byodo-in Temple agreed to cover the costs of that disposal. Case 2. The Japan Shogi Association and Kifu, Game Records. Between 2017 and 2020, a conflict arose between the Japan Shogi Association, JSA, and users regarding the utilization of Kifu. The conflict. Generally, Kifu are not considered subject to copyright. However, the JSA implemented a system requiring users to apply for permission in advance. The dispute. When a shogi YouTuber's applications were ignored or flatly denied, their lawyer sent an official letter to the JSA. The lawyer threatened legal action, a lawsuit to confirm the non-existence of the right to an injunction, if the JSA did not respond. JSA stance. The JSA argued that because they have contracts regarding the priority publication of game records, the content of the matches constitutes a business interest that is legally protected. Q3. Can the owner of a physical cultural property grant permission for its reproduction based on ownership rights? A. No. Ownership and copyright are two distinct legal rights. It is generally understood that ownership, the right to possess the physical object, does not include the legal authority to grant permission for the reproduction of the work. That power belongs exclusively to the copyright holder. Q4. Is a takuhan, ink rubbing, considered a copyrighted work? To be legally recognized as a work under copyright law, a creation must meet specific criteria. It must be a creative expression of thoughts or emotions. It cannot be a mere imitation or plagiarism of someone else's work. It must be expressed, not just an idea. The expression of thoughts or emotions must fall within the scope of literature, science, art, or music. A purely technical work does not qualify as a copyrighted work on its own. Categories of copyrighted works. According to the law, works include 1. Novels, scripts, theses, lectures, and other literary works. 2. Musical works. 3. Choreography or pantomime. 4. Paintings, prints, sculptures, and other artistic works. 5. Architectural works. 6. Maps, diagrams, models, and other graphic works of a scientific nature. 7. Cinematic works. Movies. 8. Photographic works. 9. Program works, software. Q5. Is a photograph of a flat work, e.g., a mural, considered a copyrighted work? A. If a flat work, such as an excavated mural, is photographed directly from the front with the sole intent of faithfully reproducing the original, it is generally not considered a copyrighted work. This is because such a photo is seen as a purely technical reproduction lacking the creative intent required by law. Q6. Is a photograph of a 3D object, e.g., pottery, considered a copyrighted work? A. Yes, usually. Courts in Japan tend to recognize the copyrightability of photographs of three-dimensional objects. This is because the photographer must make creative choices regarding lighting, angle, and composition to capture the object's form, which reflects the photographer's individuality. Q7. Is an archaeological excavation report considered a copyrighted work? A. Yes. The way the research process, methods, and results are expressed typically reflects the author's ingenuity and personality. Since the writing is not considered commonplace or standardized expression, the text is usually recognized as having creativity and thus qualifies as a copyrighted work. Practical handling of reports. It is safest to assume that both the text and the photographs within an excavation report are protected by copyright. Other legal considerations, portrait rights and ownership. In addition to copyright, digital archiving requires careful attention to portrait rights, the rights of the land, site owners, and personal privacy. Portrait rights, right to one's image. The Supreme Court of Japan has established that an infringement of portrait rights occurs when the violation of a subject's personal interests exceeds the limit of social tolerance. This is determined through a comprehensive consideration of the following factors. 1. The social status of the person being photographed. 2. The nature of the activities being captured. 3. The location of the photography, filming. 4. The purpose of the photography. 5. The manner in which the photography was conducted. 6. The necessity of the photography. Land ownership versus copyright. When publishing excavation reports online, is it necessary to obtain the consent of the owner of the land where the ruins were found? The legal standing. Legally, the answer is no. The ownership rights of the land, the site of the ruins, and the copyright of the excavation report are entirely separate legal entities. Therefore, from a purely legal perspective, you do not need to obtain confirmation or permission from the landowner to publish the report.